Good afternoon. My name is Paul Gore, Director of Community Development for the Asian Chamber of Commerce, Houston. Welcome to our ACC Learning, April 23rd, 2020. The Asian Chamber of Commerce has been monitoring the COVID-19 situation since January, affecting our Asian business here in Houston, and happy to put together a wonderful webinar with one of our ACC members, Nguyen & Chan LLP law firm, to talk about reopening Houston businesses and what employers should focus on and that could help save money for their business. We are an organization celebrating 30 years helping the Asian business community to foster economic trade among our members, and this is a crucial topic about resources that could help your business stay afloat during this uncertain and trying times. But before we continue this webinar, I'd like to provide some housekeeping items. First, we'll be having a Q&A session at the end of the presentation. You can ask questions through the Q&A button on the control panel located on the lower portion of your screens. If you have any questions during the middle of the webinar, please submit your questions there. We'll try to answer all the questions asked, but please forgive us if we're unable to answer any questions because of time constraint. Just want to let you know ahead of time. So in continuing this webinar, I'd like to pass the mic to your presenters, Irving and Brian, both partners at Nguyen & Chan law firm. Irving and Brian.
Hello, everyone. And let me just share my screen real quick. So my name is Irvin Chonglo. I'm a partner at Nguyen & Chan LLP. My focus or my practice revolves around business immigration, labor and employment, and corporate law. So today I'm going to be talking about a guide for employers when they're thinking about opening back up. As we hear in the news, Texas is planning to open up its businesses and the country prepares to open up. We're here to provide some guidelines and just some tips for employers to watch out for in order to make sure that their opening is smooth and safe. Now, as a disclaimer, this presentation doesn't constitute legal advice, and it doesn't create attorney-client relationship. The laws referenced here could be changed, in the near future. Please don't rely on this presentation for your interpretation of your particular situation. If you have any legal question regarding your particular situation, you should consult with a properly licensed lawyer. Now, first, I wanted to talk about the recent legislation and regulations and executive orders that have been released recently. I wanted to talk about three things. Governor Abbott's executive orders and Texas guidelines for reopening businesses in Texas. Mayor Turner and Judge Hidalgo's executive orders and local guidelines. And President Trump's guidelines for reopening the country as well. And lastly, I'm going to be talking about the Families First Coronavirus Response Act, and specifically what employers are required to do for their employees. Now, you may have heard that Governor Abbott has laid out his plan for reopening Texas. He essentially released 3 executive orders for reopening Texas in the near future. One of the orders was basically to create a task force or strike force that's made up of business owners and business leaders, and they are tasked with giving him advice and letting him know about the best ways on creating plans for reopening Texas. One of the other executive orders essentially stated that schools will remain closed for the remainder of the 2019 and 2020 school year. Now, starting this Friday, 12:01 a.m., retail services that are not essential but can provide services through either pickup or mail or home delivery can be reopened on Friday. But they have to follow the guidelines for social distancing and the guidelines set forth by the Texas Department of State and Health Services. Now, what are these guidelines? For these businesses that are opening up on Friday, all their employees must be trained on environmental cleaning, disinfection, and essentially hygiene and etiquette for respiratory. Your employees also have to be screened for coronavirus symptoms. So that's, we're talking about shortness of breath, cough, worsening cough, sore throat, loss of taste and smell, feverish, feelings. Essentially, if you know what the symptoms are for coronavirus, you're supposed to be screening your employees. If your employees are entering the business, you're supposed to make them wash their hands and sanitize their hands. Employees are also supposed to wear face coverings. Now in Harris County, there's also a face covering order that I'll be talking about later. Again, employees have to maintain social distancing, so that means at least 6 feet apart from each other. And customers cannot go in the premises. They can only do pickup or have their items delivered by mail or to their doorstep. Now, again, these are the guidelines set forth in by Texas Department of Health in terms of what employers are supposed to follow when they're opening up. Now, also with the executive orders, gyms, salons, so hair salons, nail salons, in-person dining, bars, food courts, massage establishments, tattoo piercings are still prohibited from now. People also can't visit their nursing homes, state supported living centers, assisted living facilities for now, unless they're there to provide critical assistance. There's also a change in order for medical procedures. So from April 21st to May 8th, elective medical procedures can now be performed, but the hospitals or the locations that are performing these elective medical procedures have to follow certain things. So they have to promise that by doing these elective medical procedures, that that they're not using up any PPE that's supposed to be meant for treating coronavirus. Also, the locations, the hospitals that are performing these elective medical procedures, they have to promise that at least 25% of their hospital capacity are reserved for coronavirus patients. And lastly, these hospitals that are performing these elective medical procedures, they're promising that they're not going to request any PPE from any public sources for the duration of the crisis. Now, these are just the current announcements from Governor Abbott. He says that he is going to give more guidance in the future. He said he'll give more this Friday, April 27th, and in May. So this guidance is going to come from Governor Abbott and his task force, and I'm sure he'll provide more concrete plans for, let's say, later on in May and in June in terms of opening up the businesses. There's also been some announcements on the federal and local level. President Trump recently announced his own executive order for temporarily, halting immigration to the United States. He has actually released the executive orders and the details now, so I'll be talking about it later. He also announced a three-phase approach for opening up the country. The three-phase approach essentially makes the states judge their own situation. So they have to take a look at the rate of the coronavirus growth, or how many patients are getting it, if it's on a decline, the rate in terms of infections, in terms of death. So once they make a proper determination, they can be put on 3 tiers. So there's low, medium, and high risk. So based on the category that you fall into, there are specific guidelines for how businesses are supposed to open up in that specific state. So let's say California and New York, I'm guessing they're going to be on the higher tier. So there's going to be a lot more restrictions for them opening up than, say, other states that have less cases. Now, Judge Hidalgo also recently issued a face mask requirement for Harris County, Texas. Now, this order comes with a little bit of controversy because there's a lot of pushback from locations or from organizations like the police, actually, and some other counties. Other counties are saying that these orders are not going to be followed by them because it's a little bit too restrictive. This is because for the Harris County order, they're saying if you're caught outside without a mask, starting Monday, you can be issued a $1,000 fine or up to 180 days in jail. Now, the controversy is that the say HPD and the police, they're saying it's hard enough to deal with the community and maintain the relationship without having to, having to tell people to wear their mask and or otherwise they'll get fined or go to jail. So there's a little bit of controversy, but there's also some exceptions that Judge Hidalgo put in the order. I think some of the exceptions are if you're exercising outside, then you don't have to wear a mask. If you're at home, of course, you don't have to wear a mask. But that's the order for Harris County. Again, Houston Mayor Turner and Judge Hidalgo, they haven't offered specific plans for reopening up Houston, but they said that with any future plans for reopening up, it's going to include social distancing and wearing face coverings in public. So that's just something that we have to watch out for. As I mentioned before, President Trump recently signed an executive order suspending immigration to the United States. And there's a lot of confusion and a lot of questions regarding this order. So I wanted to just provide a brief update just to clarify. This order is essentially suspending immigrant visas for certain groups of people that are trying to come into the US for at least 60 days. Now there's a possibility of extending this executive order, but he hasn't said it yet. What does this mean? This means that if you are outside the country and you are eligible for an immigrant visa is basically the visa you get when you're outside the country so you can come in and be a green card holder. So these individuals who are outside the country who are eligible for this green card immigrant visas, but they haven't gotten yet, there's a suspension for them getting these visas. So this group includes family members of green card holders here who are abroad, parents and siblings of American citizens who are outside America, and applicants through the diversity visa program currently can't get their immigrant visas to come to the US. There's a lot of exceptions for this though. So if you already have your green card and you're outside the country, of course you'll be allowed to come back in. If you are a green card applicant and you've been approved and you're a spouse or a minor child of a US citizen, they'll let you in. If you are filing for green cards inside the US, you're still allowed to apply for your green cards. If you have an approval for your EB-5, you're still allowed to apply for your immigrant visa and come in. And temporary visas like student visas, F1s, work visas like H1 and L1, they're not affected. So those visas are still allowed to be obtained. Now the issue is right now there's a lot of consulates that are closed still due to coronavirus. So they're still having a little bit of trouble trying to get these visas, but there's not an outright ban on them. How is this going to affect employers here in Houston and the U.S. if they have employees that are stuck outside the U.S. And they have their green card applications ready and they're about to come in? There might be some delay or some pause for when they're able to come in. Also, this order doesn't include members of U.S. Armed Forces and their family members. Of course, there's also a catch-all. If you're allowed to be in because it's in the best interest of the U.S. for national interest, then they'll let you in. Now, as companies start opening back up, there's going to be a lot of issues or potential issues for their employees because, the state's planning to open it back up in Friday, but it doesn't mean coronavirus is going to stop. So that means your employees could still get sick from coronavirus, or their family members could get sick from coronavirus. So because of this, the federal government, they passed the Families First Coronavirus Response Act, which basically gives paid emergency sick leave and paid emergency family leave for employees. Now, these requirements only apply to companies with fewer than 500 employees. There's essentially 6 situations for when companies have to give emergency sick leave under the FFCRA. And the first 3 are if, number 1, if your employee is subject to quarantine or isolation because they're sick from coronavirus. Number 2, if they've been advised by a doctor to self-quarantine due to coronavirus concerns. Number 3, if they're experiencing symptoms of coronavirus and they're still seeking medical diagnosis from a doctor, but haven't gotten an official, diagnosis of coronavirus. They're still subject to getting paid the emergency sick leave. Now for this, the rate for which they have to be paid is their normal wage or the minimum wage, whichever is greater. There's also a cap of how much you have to pay them. So you only have to pay them a maximum of $511 per day and a maximum total of $5,110 total for these 3 categories. And there's a maximum of 80 hours that they can take of sick leave. Now, 4 through 6 is for employees that need paid sick time because they have to take care of someone else who is sick with coronavirus. So that could be number 4 if they're caring for an individual who's sick or has been told to quarantine by a doctor. If the employee has to take care of a child because the child's school or place of care is closed, then they're able to apply for emergency sick leave. And number 6, if the employee is experiencing any other condition set forth by, the Health and Human Services for the federal government. Now, number 6 is essentially a catch-all that allows the government to say, oh, this condition also applies for emergency sick leave. They haven't specified any conditions now for that applies to number 6, but they could do so in the future. The difference between this one is from 4 to 6, you only have to pay your employees 2/3 of their normal wage. And the sick leave for these categories is capped at $200 per day and $2,000 total. Now, I discussed before which companies are eligible or have to follow these rules. If your employees are healthcare providers or emergency responders, you can choose to exclude them from these emergency sick leave and emergency family leave. Again, employers with fewer than 500 employees are the ones that are subject to these restrictions. So if you have more than 500 employees, then you're not subject to these requirements. When you're counting whether or not you have 500 employees, you have to count your full-time and your part-time within the US and any territory or possession of the US. Also, when you're counting your employees, you have to count the employees on leave, or if you have temporary employees that you're sharing with another company. If you've laid off or furloughed employees, they're not counted towards this 500 employee count. Yeah, also, independent contractors aren't counted for these counts. Like I said before, full-time employees can receive up to 80 hours of sick leave, and part-time workers can get equivalent to their average hours of work. So this is important because later on down the roads, once we open back up and employees start saying that they're getting sick from coronavirus, the company has to keep track of what they're requesting and how many hours they're requesting and things like that. Employers are required to give these the sick leave for immediate use, regardless of how long the employer has or the employee has worked for the employer. So that could mean your employee has started working for your company for 1 day or 2 days and they get sick with coronavirus, they're still subject to this paid emergency sick leave. You still have to give it to them. Also, you can't, employers can't discharge, discipline, or discriminate against employees who take paid sick leave under this law. Also, let's say if your company has additional sick leave or paid time off available to the employee, you cannot make them take those first. You have to give this paid emergency sick leave in addition to what you already give them as benefits. And lastly, you can't make your employee find any replacements first before they can take off. Now, I know that I went through a lot of requirements and nuances about this law, and it's a little bit hard to kind of wrap your head around all these requirements and things like that. So I came up with a few hypotheticals just to kind of give you some situations that you might run into, and then you can try to answer and try to see if this situation might apply to you. All right. So my hypo number 1 is company A is a manufacturer and it has 300 total employees. They have two employees, employee A and employee B, and they're both full-time employees that have gotten sick from coronavirus. They've also been diagnosed by a doctor to stay home and self-quarantine. Now, employee A and employee B, they're asking the company for sick leave because they have coronavirus. The company says employee A is not eligible for sick leave because he has only worked for the company for 3 days. Employee B is told that before he can take off sick leave, he has to find someone to cover his shifts first. Then he has to use his 5 company vacation days before he's allowed to have a maximum of 5 sick days covered under the FFCRA. Now, employee files a complaint against company because he's saying he's eligible, and company A decides to terminate him. Now, what did the company do wrong? Seeing as nobody else is on the mic and I can't see your chats, I'll just be answering the questions myself, and you can just follow along. So hypo number 1. So employee A should not have been denied sick leave under FFCRA. Employee A, even though he's only worked there for 3 days, he's still eligible to get sick leave under the FFCRA. Now, employee B also should not have been forced to find someone to cover his shift before he can take off sick leave. Again, employee B is also not required to use up his PTO first before he can take the sick leave guaranteed to him by the FFCRA. Employee B is also given a maximum of 80 hours or 10 days of paid sick leave under FFCRA. So the company could not have only given him 5 sick days. And lastly, the company should not have terminated employee A for making a complaint against company A. For my second hypo, company B has a total of 490 employees on April 30th. Now, on that day, employee A asks for sick leave because he got coronavirus. Company B gives him the paid sick leave under FFCRA. Now, a month later, on May 30th, company B hires more workers and now has 510 employees. The next day, employee B gets sick with coronavirus and asks the company for the same emergency paid sick leave as employee A. Company B denies him the emergency paid sick leave, and employee B threatens to sue the company under the FFCRA because employee A was given a different treatment. Is employee B going to win? The answer is no. So whenever the company has to count whether or not it's eligible or has to follow the FFCRA, they have to count the employees on the day that the employee requests to leave. So employee A, when he requests to leave, there were still 490 employees, so they had to follow the rules. Now, employee B, when he asked for it, the company had 510 employees. So at that time, the company was not subject to the FFCRA anymore. So they're allowed to deny employee B, even though he has the same coronavirus as employee A. For hypo number 3, company C has 60 employees on April 30th. Now on this day, employees A and B ask the company for paid emergency leave. Employee A takes the emergency leave on April 30th and is scheduled to be out until May 10th. Employee B is scheduled to take the leave on May 4th and is scheduled to be out until May 20th. However, the company closes on May 3rd because there's no work available. Employee A's and B are telling company that even though it's closed, it has to pay them the entire leave that it requested because they've already agreed to it. Does company C have to keep paying employee A and employee B even though it's closed? So company C only has to pay employee A for all of the days he took off on leave until the day the company closed. The employee B doesn't get paid at all because he hasn't taken the leave yet before the company closed. You only have to pay the leave until the day that you close. Now, this is closure due to lack of work available, not due to coronavirus or coronavirus concerns and quarantines. or Hypo 4, we have a company D, who has an employee who's sick with flu-like symptoms. Now, he already used up all of his PTO and his vacation time during the year. This employee believes that he has coronavirus and takes off 2 weeks without going to the doctor to get official diagnosis of coronavirus. Now, once he comes back, he asks the company for his sick leave pay under the FFCRA because of his illness. The company refuses to pay him for his leave. Now, who's right? In this situation, Company D is right. Company D is right because Company D only has to pay for sick leave if the employee has an official diagnosis of coronavirus. If there's no official, coronavirus diagnosis from a doctor, even if the employee has all of the symptoms, cough, fever, then it doesn't matter. He has to get that official diagnosis from a doctor before the company is allowed to pay him. Now, if the employee had additional sick time or vacation in his bank, then yes, the company, if it's following through on its benefits, then we'll just give him the benefits under that company benefit plan. But in terms of FFCRA and the paid sick leave requirements, no, the company doesn't have to pay him in this situation. Now, there's also the emergency family leave, which gives additional 10 weeks of paid expanded family leave to employees if they're unable to come to work because their child's school or place of care has closed because of coronavirus concerns. Now, for this situation, only employees that have been on the job for at least 30 days are eligible for this emergency family leave. Now, you can see, even with this one, with the paid sick leave, there was no requirement for having worked on the job for however many days, but on this one, there's 30 days. But even so, these requirements are still pretty lenient towards the employees, so you have to watch out for this. Now, there's a small business exemption for businesses that have less than 50 employees, and essentially, if an employee is asking for paid emergency family leave or sick leave because their child's school or place of care is closed due to coronavirus, the company can say that they cannot grant it to them. Essentially, the company has to prove that granting them the leave will jeopardize the viability of the company's business. And basically, the company has to say it's going to essentially stop or ruin the operations. Now, for this exemption, there's actually no formal application that you have to give to the Department of Labor, so you don't have to send any paperwork in. But whenever the employer has to make these determination of whether or not they're exempting an employee from being able to take this family leave, the company they have to make proper documentation to support their internal finding. This is because whenever you deny an employee this leave, they may go and make a complaint, or they may make some noise saying they're eligible and the company's wrongfully declining them this leave. So if that happens to be the case, the employer has to have proper documentation to provide, if Department of Labor comes in, that they can provide to them and show that, look, we were qualified under this small business exemption. Now, what does the company have to prove? Essentially, the company has to prove one of three things. Number one, if the employee's leave will cause the expense of the company or its financial obligations to be higher than the company's current business revenue, then yes, they can be exempt from this. Number two, if the employee who is asking for leave is very special to the company or has specialized skills and knowledge that their leaving will cause substantial risk to the company's operations, then yes, they could be exempt. And number three, if the employer can't find a suitable replacement for the person who's leaving, then yes, they can exempt them. Now, number three gets tricky. So if you have, say, 3 or 4 or 5 employees doing the same job duties with the same job title, it's going to be a little bit harder for you to prove this person who's leaving, I can't replace them, if you have other employees who can do the same thing. So again, you have to watch out for these 3 criteria on whether or not you're qualified to go for the small business exemption. And again, this is only for if your employee is asking for leave because their child has to be taken care of at home because their school or place of care is closed. It's not eligible for the other types of leave. Now, all this requirements, it's definitely going to put a lot on the employers in terms of financial burden. Now, because of this, the federal government has provided a payroll tax credit that's supposed to help employers. Now, normally employers, they're supposed to be withholding federal income taxes and Social Security and Medicare from their employees' paychecks. And then the employers are supposed to pay that to the governments every quarter or so. Now, with these new tax credits, eligible employers who pay these leaves to their employees are able to retain that amount of payroll tax that they paid to their employees and essentially keep it instead of having to pay to the IRS. Now, again, you're only allowed to get these tax credits for paying for these emergency sick leaves and family leaves, not just if a person had to go on sick leave that's not related to coronavirus. So again, this is only for coronavirus related leaves. So I have a couple more hypos to go through for this emergency family leave. So company E is a manufacturer and employee A is their plant worker. So plant worker, and they have to do all the work at the plant. They can't take it home. Now, employee A's child has to stay at home because their school closed due to a quarantine order from the city. Now, the employee can't find somebody to watch her child, so she asks the company for family leave to stay at home and take care of her child. Again, she's not able to work from home because the company doesn't offer that option. Company E tells her that because she's not working at home while taking care of the child, they will not have to pay her. Is company E correct? Now, in this scenario, no. Because the employee is unable to work because he needs to take care of a child due to a quarantine from coronavirus, then the company has to pay them for the emergency family leave. Now, if if there is a telework option at home and she is not working because of that telework option, then yes, the situation could be changed. But because in this situation, there is no telework option at home, the company has to pay her the family leave. For hypo number 6, we have company F who has an employee that has a child. Now, because of coronavirus reasons, the child's daycare is now open only 3 days a week. So that means for 2 days, the employee has to stay at home and take care of the child. The company doesn't offer the option to telework for this employee as well. Now, because of this situation, the employee is asking the company to give her paid emergency family leave for 2 days a week for the next 10 weeks. Is company F allowed to give it to her? Now, for this hypo, is essentially asking, if the employee wants to take intermittent family leave instead of all at once. So instead of all 10 weeks at once, can she take it 2 days at a time for the next 10 weeks or so? Is a company allowed to do that? Now, in that situation, yes. So as long as the company and the employee agree to it, then yes, they can give her the intermittent family leave. The key in this situation is that the employer has to be agreeing to it. Now, for my last hypo in this situation, company G has 2 employees that they know are married to each other. They have 4 children whose schools have closed due to coronavirus, and the kids must now be taken care of at home. Now, because they have 4 kids, the 2 employees are asking the company for the paid family leave at the same time because they're claiming that they need 2 parents to stay at home to take care of the 4 kids. Company G tells them that only 1 parent can take the paid emergency family leave at a time. Can company G do this? So in this situation, yes, because the company knows that they're married to each other, they know that at least one of them would be available to stay at home to take care of the kids. If the company knows that there's a co-parent, co-guardian, or childcare provider available at home, then they don't have to give them the emergency family leave for the other person. So in this case, I made it specifically that the two employees are married to each other and the company knows this. So in this situation, they only have to give the family leave to one of the employees at a time. So let's say one of the employees takes 10 weeks and the other employee after that takes 10 weeks. That'll be fine. But in this situation, they don't have to do it, or they can't do it at the same time. So changing topics. Now, as companies start to open back up, and everybody knows the economy has gone down, and there needs to be cost cutting for employers in order to deal with the current situation. Because as many of you know, revenue has gone down for a lot of businesses. Just to provide an update, more than 2.1 million people around the world has been infected by coronavirus, and more than 140,000 have died from this disease. In the U.S., I'm sure this number has gone up since we made this PowerPoint, but it was approaching 650,000 in infections. And right now, federal, state, and local officials are rushing to contain the spread of disease in the U.S. And because of this, for-profit businesses have taken the brunt of this attempt to contain the spread of disease. That means they've closed up.
Hey, Irvin, it's
yes.
Brian. So I apologize to everybody. I was in a Zoom hearing with the federal court, and so apologize for the minor delay, but I can take it from here if that's okay.
Sure, you can go ahead and take it.
Okay. So as Irvin was telling you, that this epidemic is unprecedented, and it has not only threatened lives and taken lives, but it has taken livelihoods, and it's impacted what this great economy is founded on, which is mostly small businesses. Big businesses are hurting too, but small businesses typically don't have the ability to absorb or the cash reserves to deal with such a crisis. And so what I want to talk to you today about is the number one way of dealing with this is mostly going to be cutting costs and the implications for that from the corporation, from the employer side. And so, Irvin, if we can go to the next slide, please. So there's two primary options here. You can either increase revenue or decrease costs and expenses. Unfortunately, many companies are not in a position to develop new revenue streams or to remanufacture their business. There's not enough time. And so the only option is when you're not having income or revenue, you have to decrease operating costs and expenses. However, the question is, well, how do you do that? Now, the place where most businesses cut costs is in the workforce, because they can't pay their employees without operating revenue. And this is known as a workforce reduction. How is the best way to implement such a reduction? I've given you 6 considerations, but there's not one that's overall dispositive. It's really more of what you think is best for your business and the type of workers. If you've invested a lot of into human capital and the people as employees, and you want to have them back, then the best thing you can do is to try and make them happy in the interim and not fire them or terminate them or lay them off. And so we're going to talk about ways that you can try to attract or at least try to convince your employees to bear the brunt with you. Because the fact is, if the business goes out of business, there is no work. And so, but when you choose which type of workforce reduction to implement, this has a lot of legal implications, and it can impact continuation of benefits and other type of obligations that you may have under federal and state law. Please go to the next slide. So there's different types of workforce reductions. There's furloughs, there's layoffs, there's firing for cause, reducing the amount of work hours that are available for employees. These typically apply to hourly employees, cutting bonuses and salary increases, kind of repurposing personnel, and lowering or getting rid of payments for overtime. The most pertinent that we're going to discuss here is going to be furloughs and layoffs, as well as reducing hours and compensation. So the first option, I would argue, is that's probably the best if you value your workers and want them back, is a furlough. A furlough is defined basically as an unpaid leave of absence. It basically tells the employee that it's not that I don't value you, I want you here, but I can't pay you because the company isn't making any money. We've had to shut down, like for example, a barbershop, right? At Supercuts, for example, or a restaurant. You don't need servers when all you can do is takeout or delivery. So we can talk about some of those type of scenarios. One of the key things that you need to keep in mind from a legal standpoint is that there are certain thresholds that we'll get into that are imposed on you under state and federal law based on the number of employees you have. And so furloughing an employee doesn't reduce the amount of employees for that purpose. So in other words, if you had 55 employees, the FMLA would apply to your company. And if you furloughed 10 people, it would still apply. However, if you were to lay them off, it may not apply anymore. It's going to depend on some of, the situations. These things aren't usually, cannot be talked about in a vacuum, but we'll do the best we can to try and give you context for this purpose. Please go to the next one. So another type of furlough is known as a rotating furlough. And the concept is pretty simple. Let's say Irvin and I are two accountants in a company's accounting department. Well, since there's a lot less paperwork and stuff like that, and to help spread the risk between the two of us, we may do a rotating furlough where Irvin goes on unpaid leave for 2 weeks, and then he comes back in and he gets paid for 2 weeks, and I go on unpaid for 2 weeks. And so that is something that is an option that could perhaps harmonize things. However, you have to keep in mind that people's living situations are different. Irvin may have no kids and I may have 6 kids to take care of. And so I might not be able to weather that. And these are, certain situations and circumstances that you'll have to take under advisement when you consider such an action. The other issue that's important to point out is if they're salaried employees, it's a bit more complicated. Salary employees are considered exempt under the Fair Labor Standards Act. And so you have to make sure that they're paid for any work that they have done, and it has to apply prospectively. Please, let's go to the next one. So certain legal considerations happen regardless of whether or not you furlough or you lay people off. And there's a federal statute called the WARN Act. The Texas does not deviate from the federal. Some states like California have a little bit more stricter policies or regulations under their own WARN Act. But the key thing for the WARN Act is that you first have to be a covered employer, which is with 100 or more employees. Now, this isn't typically applied to many small businesses. You know, things that you usually would take under consideration if you had a plant, for example, if you were manufacturing widgets and you had numerous employees, but due to the plant having to close due to COVID-19, you know, much in the way the meat packing plants are getting closed, you would need to provide at least 60 calendar days written notice under the WARN Act. However, this makes it a little bit different here, because if you go to the next slide, Irvin, there's an exception to the WARN Act, and this is due to business circumstances that were not reasonably foreseeable at the time. I would argue, I think it's a good argument that you could make if the WARN Act applied to you, is that you had no way of knowing, especially given all the information that's kind of contradicting from our governments, the state, local, and federal, whether or not, you know, you could have had reasonable notice here. And I think that you can say that this was not foreseeable, that this disease would become or be exacerbated as much as it has been. Now, as I said earlier, many states have their own version of the WARN Act. Texas does not. And so you would just follow the federal version of the WARN Act. Please go to the next slide. Now, when in doing a furlough, one of the most important things that you can consider legally is that you have to have a proper methodology for selecting which employees are furloughed, because you don't want to have discrimination claims. You know, typically most companies would furlough their highest paid employees. The problem with that, though, is that usually the employees are usually older employees. And so whether or not the ADEA, which we'll talk about soon, that could apply, and you can get sued for age discrimination. You don't want to furlough, you got to be careful. You can't furlough all the women versus all the men, things of that nature. So you have to have a carefully documented, I would argue that and recommend that you should have it documented as to the thinking you have for selecting which employees, and put business justifications in writing so that when you do that, if you do get sued, you can point to that, which will be an affirmative defense. Please go to the next one. So what happens to employee benefits when employees are furloughed? Well, that depends. Because they're viewed as employees on unpaid leave, you will need to review your handbooks, your company policies, and the policy you have, for example, with healthcare insurers. I would advocate to everyone that everyone should update all their corporate policies and handbooks to include COVID-19 directed policies. We can get into that later, but I think that would be something that would be very important, so you can have that addressed. You have to consider whether or not the employee's insurance coverage will be terminated as a result of the furlough. Again, this is dependent upon the company's policies as well as your contract with the insurance company. Please go to the next one. So the best practice to do is to look at the plan document to see whether or not it addresses this situation where employees are furloughed. If it does not, and you want to either amend the existing policy, or if you want to add additional coverage because you want to take care of your employees, you should do the following. You should amend the plan to provide the desired coverage, and you must procure from, like, for example, Blue Cross and Blue Shield, written permission to provide this coverage. Because if you don't get written permission, this could result in an insurer disclaiming coverage. Now, notice that you'll have to pay, the employer will have to pay for it, I'm sure, but you do need to have the insurance company's blessing to provide more benefits than they're contracted to. And don't forget, given that Obamacare still applies, a key component to determining if those on furlough are covered by a plan is the manner in which full-time employees are determined under Obamacare. Please go to the next one. Next question would be about, well, what about I have a 401k and they match it? Does that mean that they have a right to not match it anymore? Well, that depends. In a nutshell, and you clearly read all this for yourself, but it depends on whether or not you have a safe harbor plan or a non-safe harbor plan. And I'm not going to get into all the nuances of that. That's a topic for another. That 401ks and retirement plans would take up a whole training session by itself. But here are some of the factors that you need to consider. It is not automatic that you can just cut it off. However, the fact is that if you can justify it, that you can't afford to match anymore, not that there's a decrease per se in profit, but if you honestly can't afford without the company being severely injured, you can clearly get out of contributing to retirement plans. But this is not a one-size-fits-all discussion on this topic. Please go to the next one. The other thing that's very important is employers must be careful in avoiding wage and hour violations for furloughed employees. You have to pay for any work performed. So in other words, you need, when you furlough an employee, I recommend that you specifically write to them what they can and cannot do, because if they check their emails and it's work related, that can be considered work for a non-exempt employee who should be paid hourly for it. And so you need to document. When in doubt, document as much as you can. Okay, go to the next one, please. Layoffs. COVID-19 doesn't really change the analysis of the legal implications of layoffs. That just changes the business considerations for the most part. But in any event, I would argue to you that if you it's better to, in these kind of times, to furlough people than to lay people off, because laying off people, it's different in the sense that it's considered permanent. In other words, they no longer count as employees. It's more, in some respects, it's more of a psychological reassurance to the person that you're wanted here, and that if it wasn't for this business issue, I would keep you, versus a feeling of rejection. Now, the rule that applies to a furlough also applies to a layoff. You can't just lay anyone off or furlough anyone off. You want to, you have to conduct an analysis that is non-discriminatory and does not have a disparate impact on a protected class. In other words, as I said before, you can't lay off people of one gender, one ethnicity, or one age type of class of people. Now, and again, as I mentioned, you should document. This is very important. Document either when you do layoffs or you do furloughs, document your thought process and substantiate it with legitimate business reasons. Now, note, in the small business sense, not all of these type of laws apply. For example, companies that employ 15 or more workers are required to adhere to Title VII and the ADA. The ADEA, the age discrimination statute, applies to employers with at least 20 employees. And FMLA applies to businesses that have at least 50 workers. It's important to note, though, that even if it doesn't apply to you, you should probably follow these guidelines anyway, because you don't want to be known as an employer that it discriminates in any way. And that reputation will catch up with you. Please go to the next slide. So another aspect that you can do is basically trying to cut costs by reducing hours or in compensation. Essentially asking someone to take a pay cut reduction so that you can afford to keep them on, and that when times get restored, that they can get compensated back to their compensation or even made whole again. For a non-exempt employee, this is pretty straightforward. In other words, an hourly worker, if you say, well, you get paid $10 an hour and you work 40 hours a week, I can cut it down to 10 hours a week, right? Then they just get paid $100, $10 an hour for 10 hours, which is $100. For salary workers, you just have to be sure to be mindful that they must earn still at least $684 per week to maintain the applicable exemption under the Fair Labor Standards Act. Otherwise, they'll be entitled to overtime. Okay, let's go to the next one. One other thing that you can do before, I always say that it's better to kind of go to the employees first and say, listen, here's the situation. It's better if they're willing to assist the company than you having to make them. And so companies should consider first seeking volunteers to take an unpaid leave or reduction in pay, either a sabbatical where they're guaranteed to get their job back, or there's not a guarantee, but there's a presumption they'll return. Now, one of the caveats to this is if you have someone with an employment agreement, you would have to amend that employment agreement as to not breach them. One of the attractive circumstances, for example, is you can offer the carrot of that you can avoid potential COVID-19 exposure if you're willing to take a sabbatical. In certain, like retail establishments, that would make sense for people versus resorting to mandatory cuts. Again, it's a lot better when they feel that they're part of the decision than being forced onto them. And so this is a time where you need to be good to your employees, because you're going to need them at some point. The economy will start to get back up again, and you're going to need the people that you've relied on all along to be there with you. Now, one thing you need to understand, though, is that when you're cutting the hours of full-time employees, you have to notice whether or not it will render the employee ineligible for benefits. So you will have to check the policies and the benefits contracts. Please go to the next slide. Okay, so there's one thing that the governments offer, state governments offer, is something called a work share program. And a work share program is essentially where the state kind of helps fill in the gap and provides some of the short-term compensation while allowing them to work. You know, a lot of this information is pretty straightforward, and it can easily be found on the TWC website. I would suggest reading more about that in detail, given that we don't have, you know, our time is limited today. But work share programs are an excellent solution to trying to kind of have your cake and eat it too, to take care of your employees while at the same time reducing your financial burden. Please go to the next slide. It's important to note that to the extent employers use independent contractors or leased employees, the employer may be able to terminate an existing arrangement. However, you have to review the contract to ensure that you understand the termination requirements. And so what you'll see here is that most companies will either, if it's in the contract, the force du jour clause, or say that it's an impossibility because the company shut down. So therefore, I'm not getting any consideration because you can't work, and I shouldn't have to pay you because of that. And I think there's going to be a lot of litigation in that respect. And we can talk about that. That's a whole nother subject to talk about, but that's something that you need to be cognizant of. Please go to the next slide. So there's a lot of, one of the biggest things, whether you furlough or lay people off, is unemployment insurance considerations. Now, you have to note that a worker doesn't have to be totally without a job, as I previously stated, to be eligible for Texas unemployment benefits. Some aspects of it are intertwined with the work share program, but even not, the TWC has basically said, if you have reduced hours due to coronavirus, we want you to apply. And whether or not those people get it, you know, really is kind of based on the TWC's criteria. Given our limited time, we won't go into that. But the question is, how does that impact you as the employer? Well, it does. If an employee collects unemployment benefits, you get a chargeback. And a chargeback is basically charged to an employer's tax account for use in calculating the unemployment tax rate, which results in increased state tax rate. So in other words, it's going to cost you money at the end of the day. Please go to the next slide. However, there's some exceptions. An employer may be eligible for protection from the chargebacks from unemployment benefits if the evidence shows that the work separation was for medical reasons. Unfortunately, this provision is not going to apply to preventing exposure. However, if the person got COVID-19 and had to be separated due to a furlough or something to that effect, you would have no choice but to try and argue to the TWC that you shouldn't be charged a chargeback because of this provision. Now, Your better argument, though, is to shut down prospectively. If you were in the restaurant business or the retail business, is if a business shuts down due to a closure order from the government. And that happened for the most part. And so all you need to do is to include a copy of the shutdown order with your response to the unemployment claim and argue that the closure was mandated by a local or state order, and therefore you will be immune from the chargeback. So that is a very important consideration here. Please go to the next one. In summary, unfortunately, there's not a lot you can do to kind of avoid the inevitable when your revenue is down or you have to shut down. But you need to be cognizant of your litigation risks, and you must document however you decide to do a reduction in force and support it with legitimate business reasons to insulate yourself from liability. And of course, if the Federal Warrant Act applies, you definitely want to follow that, or if there is a state warrant act. Always seek legal counsel, though, I think, before you make a decision, because there might be situations where you don't have a choice but to lay off people who happen to be of the same ethnicity, because you don't have a lot of employees. So it's important to always seek legal advice if you have any questions or uncertainty about an action. Please go to the next one. So the next topic we're going to address briefly is the implications of reopening the economy and potential liabilities for employers. So the government says, okay, it's time to reopen. But what happens if you go reopen and either customers or your employees get COVID-19 and you didn't require them to wear masks, you didn't do anything? You know, what is your risk? Well, OSHA has developed guidelines, and what they recommend, and I would recommend at this time, is to develop an infectious disease preparedness and response plan. Although this doesn't protect you, nothing is like a shield, it certainly helps. And having policies such as this in place show the reasonableness that you went to protect people. Now you have to keep in mind that OSHA's and guidelines are not binding. It doesn't create new or alter any legal obligations that currently exist, including those that OSHA currently has. OSHA has divided the exposure in their guidelines to certain types of risk, people from very high risk to low risk. And you'll see if you go to the next one, this will be before we go to the next one, I'm sorry. What you'll notice is that the people in the high risk category, they are the ones who are on the front lines. And what I mean by that is people working with people suspected to have COVID or have COVID, right? Your emergency room doctors, your infectious disease people, your respiratory therapists, people of that nature, morticians, and people on the lower end of the spectrum are now typically people like in a bank or a law office, because they typically work more than 6 feet from other people or don't have as much direct face-to-face contact. However, I would caution you this. The evidence has shown that most of the spread is done by people without symptoms, non-symptomatic spread. And so, although OSHA may not have caught up with the medical data, you should, not only for legal reasons, but more importantly, for the health and safety of yourself and your workers. Because at the end of the day, people are the most valuable resource and capital, and you want to take care of that. And so I would argue that it would be good to have some sort of PPE to make sure that you take care of that situation. And in fact, it may be a good idea to create your own OSHA type poster and post that at the workplace, basically saying, please know there's COVID-19, you need to wash your hands, those kind of things. Wear a mask to avoid spread, and also say that, listen, most COVID-19 is spread by non-symptomatic people, so please maintain social distancing. I think if you do that, it's kind of no different than when you go to a grocery store and you see the slippery when wet floor signs, because you would be responsible for a dangerous condition at that point. Okay, so let's go to the next slide. So there's some burning questions that people may have. Number one, how many hours is an employee obligated to pay an hourly paid employee who works a partial week because the employee's business has closed? Well, if they are, it depends, but the safe answer is you are not responsible for paying an hourly worker time that they didn't work. And so that one is pretty standard. But an alternative question would be, what if it's a salaried employee? Well, that gets a little bit hairy, and it depends on what they have done up to that point. Another question that would be common in these situations: do employers have to pay employees their same hourly rate or salary if they work at home? The answer is, it depends. It depends on the arrangement you have with the employee. If they are doing the same thing, and there hasn't been any arrangement otherwise, and that it's their understanding that they're getting the same pay, then the answer would be yes. Now, no, if the work from home is a reasonable accommodation for a qualified individual with a disability, or is required by contract, then you have to pay. If it is not the case, though, you then only have to pay if they're hourly, the hours that they actually work. And so you would have to be diligent in having them record the time that they did at work, especially if they're non-exempt. Okay, next one. May an employee require an employee who is out sick with COVID-19 to provide a doctor's note, submit to a medical exam, and remain symptom-free for a specific amount of time before returning to work? Typically, the answer is no. You don't have to have all that. You need to just have something specific, basically saying that they are able to return to their duties, that they're not infectious, but however, this is a different type of scenario. And so what you may, and I know HIPAA applies here, but this is unique circumstances. I think that this is a gray area. I think it would be reasonable to require not just a doctor's note, but a actual COVID-19 test showing that they are negative in accordance with the CDC guidelines. Because again, allowing someone to return just based on a note or something like that without the requisite proof opens yourself up and you expose the workplace unnecessarily to this disease. So another question is usually asked, what should an employer do if an employee refuses to come to work though they are not ill and have not been exposed? In other words, they're saying, I don't want to get exposed. I'm worried, I'm not coming in to work at the Gap because of this virus. Well, the fact is that, that's insubordination. And, if they want to argue that there is some kind of accommodation that needs to be made, they have to follow the ADA process. So you could discipline them, you can fire them, but you have to be, and I would document all this. They're making a conscious choice, and you have to respond to that choice. I think the law will evolve on this, but I think right now it's safe to say that especially if they're an hourly employee, the decision becomes to you whether or not to make a furlough, which it sounds like they would do, or you can lay them off. I would recommend that you would furlough the employee right now. They're not getting paid for it, but they can still have their job, assuming things return back. The next one, can employers require employees to self-report if they have COVID-19? This is a tricky one, and the law is evolving here. However, the fact is that there is a legal responsibility to keep the workplace safe. And so I think that you're on solid ground to require the employees to self-report if they have COVID-19 under these circumstances. Because this is no different than if they had spilled a chemical over the floor that could cause people to slip or something like that. I would argue that this is very similar in the type of almost premises liability type of situation. But I would say that you need to protect that information. And this is where having those COVID-19 policies are going to come in handy on how to deal with it. Okay, please go to the next one. This is just the OSHA pyramid that I discussed before. And I'll leave, if we can go to the next one, Irvin. We're almost done. Keep going. Keep going. We'll end on this portion here. So this gets to what I was talking about before, is are you liable if you don't do anything and you don't protect people? Well, people can file claims of negligence, intentional or negligent infliction of emotional distress, gross negligence. A great example of this is the Princess Cruise Line suit for gross negligence, and basically saying you allowed passengers unnecessarily to be exposed to COVID-19 on a cruise ship. And so this is a scenario where I envision there will be a settlement because there's some damning evidence there saying that they didn't do what they could. Now, without getting into it further, you don't want to be in the Princess Cruise Line type of situation. You want to have this, unfortunately, they were caught without any notice. It kind of hit them all of a sudden. Here you have a little bit more notice of this situation, and you should be proactive in dealing with it and drafting the appropriate policies, and as well as, I think, an OSHA statement regarding this COVID-19 pandemic. If you want to go to the next one, I think that. And so I'll leave you with these three final points. Again, it's the law practically in every state. I mean, it is the law. Business owners have a duty to take reasonable measures to limit customers and as well as employees' exposure to dangerous conditions, as I've been discussing. However, currently, there is no specific heightened or enhanced duty to follow the CDC guidelines. I would argue, though, even though that may not have been determined by any court or has not been prescribed statutorily, it would be good practice, best practice, to follow the guidelines to reduce the claims. People are less likely to sue if you follow these guidelines. It doesn't mean if you don't follow them, it's indefensible, but it makes it a lot better. Because again, who's going to be judging this? It's going to be a jury. And so they're going to want to see that probably. And the last issue is causation. This is where you'll gain the most traction on defending a case and say mere exposure does not equal causation. How do you prove that you didn't get it on the way to work pumping gas, right? You might have contacted it then, and the fact that you're exposed to it at work is meaningless. This is going to develop more when the contact tracing is further developed, and it'll allow plaintiffs an easier scientific path to proving causation. Okay, I think that's all. And then we leave you off with best practices. I think you can read these for yourself. But again, you should follow the CDC guidelines, in my opinion. Okay. Thank you for your attention. And we'll do some question and answer.
Brian, Irvin, thank you so much for this particular time of giving a lot of information for our attendees. We're going to have some question and answer session with the last minutes that we have for this particular webinar. In that perspective, we had some that came through our Q&A box, and I know some of them were answered already through your presentation and some through the chat box that we're having some of our back-end people answering questions on the side. But I think Irvin was talking about immigration, so I want to say one of the questions that came in was, how is TN visa still able to enter the U.S. and work? Is that still possible through some of the legislation, what Trump did earlier this week?
Okay, so the executive order that Trump signed this week, that's only for immigrant visas. So those are only for green cards, permanent residents that are trying to come over here. The TNs are non-immigrant visas, so they're over here temporarily for work. So those shouldn't be affected by that executive order. Now, there's also a few other factors that may affect TN though. One would be whether or not the border between Canada and US remains closed or whether or not it becomes open. Number two, whether or not the consulates overseas that are processing the TN visas, if they open back up to start taking appointments. But, so it's more of a logistic problem in terms of getting the visas rather than being affected by President Trump's latest executive order.
Okay, great. One came in, I think it's probably more for Brian. Is it okay to change employees from part-time to individual contractors to give notice or simple altering the employee schedule to reduce the hours under the situation?
Well, you could simply alter this employee's schedule to reduce their hours, as I mentioned. You can certainly change them to an individual contractor, but to do so, you would have to enter into a contract typically, right? And so I don't know how much you'd want to do that, other than if you're trying to shed the obligation for the benefits. But that is an option you can offer them. But you'd have to talk to them specifically and say, listen, it's hard to answer in a vacuum, but you need to understand if you're obligated already, if you lay them off or you furlough them to, you're going to have to pay COBRA at a minimum, right? You got to offer them the COBRA benefits for healthcare, stuff like that. So if you want to get out of that, you'd have to reach an agreement, but you would still, regardless of reducing the hours and stuff, as I said, you'd have to check the benefits package, check your policies, which is why I'm saying that you need to update all this stuff. I think every company needs to update all of their policies and their handbooks with this new COVID-19. And also, again, as I said, I recommend that you have some sort of posting, some type of OSHA posting that addresses COVID-19.
Good. Another question that came in, either one of you guys, how long can a company furlough an employee? Any difference between full-time and part-time employees?
There really is no defined limit unless the time. So in other words, if furloughing equates to laying them off, then, it's kind of that kind of judgment. You could furlough people for several months, maybe probably up to a year. But again, the issue is, do you want them to come back? And are they going to be treated as though they are, in other words, is it going to restrict their ability to get another job? I don't think it will, but you can furlough them for a pretty reasonable, sizable time, probably even up to a year, depending on the circumstances. And it depends on the kind of business you're in, and it depends on how long, right? So, for example, if the government said, "Well, we're not going to have people sit in restaurants for 6 months," right? And you furlough servers for 6 months, that's perfectly reasonable. So it's going to kind of depend on the circumstances in some respect.
Okay. Another question. I'm just going to try to end this with this question and then kind of wrap it up because of time. The question here, and this is two parts. For doing furlough, the employer should pay the final pay for the employee during that time, right? Is that my understanding? That's one of the questions. And then the second part of it, the employer can't pay for the scheduled bonuses and commissions due to loss of profits under the circumstances. Is there a chance for the employee to sue the employer? Sorry.
Well, let's go back to the first one again. Let's part one of that.
Yeah. The question again was during the furlough, the employer should be paying their final pay. Is that correct? Is that from the understanding? Is that correct?
Well, it depends on the type of employee. If they are non-exempt, meaning they're an hourly worker, you pay them for the amount of time they actually work. That part's easy. If they're salaried, you have to look at it and see if it covers the pay period. So in other words, if the pay period for the salary covers the end of the week, right, and you furlough them on Monday, you still have to pay them for that entire week. Remember, it has to be prospective in the exempt standpoint. And then the second part again?
The employer can't pay for the scheduled bonuses and commissions due to loss of profit under the circumstances. Is there any chance that the employee might be able to sue the employer?
Well, I mean, part of it depends on whether or not there is a contract. First of all, let's assume that there is a contract, some kind of employment agreement or something like that. Well, then that goes to the issue of force majeure, impossibility. Now, if the bonus is kind of, more subjective based, then you have a lot more wiggle room. So I think it's going to depend on how the bonus structure is and what it is. So on the one hand, if there's a contract, you're going to have to basically prove the kind of hardship that you can't perform under it. But if it's more of a subjective thing, then you can say, hey, I know I said, we usually give bonuses out. There's going to be everybody usually gets a Christmas bonus, but we don't have the money for it. Then you can easily do that. Does that answer the question?
I believe so. I believe that's a good clarification. Again, every situation is a lot different, but I think in a nutshell, you guys did a great job. I want to, as we wrap this up, I want to say thank you to Irvin and Brian for putting this together, and Nguyen and Chen's law firm who had graciously volunteered to do this webinar. As we're closing up, you can see on the screen here, this is the website that we put up the chamber that provides a lot of the information that's been going on to help businesses with the coronavirus situation. Even you can go there and you'll find the OSHA links to posters. I think you have to go to the labor part section there, and I believe that's the link to OSHA. And in that website, they do have the posters that you can customize for your particular organization that you can post on in your I guess work group and whatnot. But we want to just say thank you and hope you guys find this webinar very useful that you can take away from our afternoon here. We'll also let you know that we have a lot of different programs. One of them is we have our industry meetups that happens every week, or actually pretty much almost every day of this week at 4 p.m. I believe today is going to be construction and real estate. So if you're a member, please sign up for that. It's kind of like our version of happy hours for industry focused. For our members to talk about resources and offer encouragement through these hard times. Next week, we'll have some more webinars lined up. We're looking at putting together one with Microsoft to talk about LinkedIn and how to use it to market your company through this economic reopening of businesses that's coming up. We also have on Friday our membership orientation starting at 10 o'clock to learn more about becoming members and just the benefits of being part of the chamber itself. Please look for announcements on our website to look for more information. For those who are not members yet, we're actually offering a 2-month free trial membership to experience some of the resources and benefits of joining. You can view that on our website, www.asianchamber-hou.org, for up-to-date information of what we're doing. If you're not on our e-newsletter, please sign up. We just kind of want to stay connected with you. And also follow us on social media with the link provided on top of our website. Again, thank you for spending your afternoon with us. And please reach out to the chamber if you have any questions. We're happy to help. I know some of the questions to have about the presentation being available. We'll go ahead and work with this law firm and the presenters to put it up for you. And hopefully you'll see that soon. Again, look for our future webinars. And this concludes our webinar today. And we'll be ending our meeting shortly. Thank you, guys.